Let's kick this off. So thank you everybody for joining our AMA today. We're here to talk about a very hot topic, probably as hot as they come in our world, and that is around the SEC guidelines regarding cybersecurity incident disclosure. So we'll start with some housekeeping, some introductions. So I'm Ivan Dwyer from Material Security, joined today by Anderson Lunsford, who's the CEO and co-founder of BreachRx, and Chris Hendricks, head of incident response at Coalition. I'll let them introduce themselves before we jump in. But first, I just want to do a little housekeeping. Again, this is being recorded. This is both a live AMA, and we have a bunch of questions that we've taken in over the course of the past couple weeks. So if you do have questions as we're talking through, use the Q&A panel, and I'll kind of be monitoring that as we go along. And I might as well, I will stop the share because I think we've seen enough of the backdrop. Let's just get our talking heads on the screen here. All right, I think this is a little bit better. Cool. All right, just organizing all my windows here. All right. So again, I imagine if you are attending, you're rather familiar with this topic, but just kind of the quick TLDR. Just a short month ago, the SEC implemented new regulations that require public companies to disclose any security incidents deemed material to investor confidence. Now, this comes at the heels of a few very high-profile investigations against security leadership at companies like SolarWinds and Uber. And since these regulations have been enacted in practice, we've seen a few high-profile filings. So the first one was VF Corp, which is a major retail conglomerate. And of course, Microsoft has had an incident. They just happen to be the largest company in the world. And then just yesterday, HPE, not the largest company in the world, but certainly has a storied history. Now, the SEC investigating securities fraud is not a new phenomenon. Regulations around security incident disclosure is also not a new phenomenon. So what makes this particular guideline so scary and so notable? So my kind of personal take here is it's because there's now this very highly visible and very highly consequential convergence of corporate responsibility and personal liability. And that's just like a really, really dangerous place for any security or risk management leader to be sitting. And so since these guidelines have been public, the industry has been reeling and a lot of chatter. Now, we're all, generally speaking, I'd say pretty used to dealing with uncertainty in high pressure situations, but mostly business and technical uncertainty, not necessarily legal situations, especially when you're personally on the hook. So in that sense, it's kind of uncharted territory. So you have questions. What we've done is, like I said, we've collected a bunch of those burning questions over the past few weeks, and we're going to just cover them today. And these questions, they span a few domains. So we've assembled this all-star panel of experts that represent both security, legal, and insurance point of view, because we feel like a lot of the topics are kind of across those areas. Now, for us at Material, we're a security vendor. We're focused on, stopping attacks and reducing risk. And we focus on email a lot, and that's just a common entry point and target for these attacks. So we've been having a lot of conversations with our customers and on this topic. And not just because of the convenient naming around material security, name association, it's kind of, what we do. And so, we thought it'd be really helpful for the community and all of our customers just to facilitate this conversation. So with that, I'm going to let our panel introduce themselves, and then we're going to dive into the AMA. We've got a lot of really spicy topics to get to. And again, if you're watching live, you hear something, think of something, drop a question in the Zoom, and I'll be watching that as we go along. All right, we'll start with you, Andy. How about?
Great. Yeah. Thanks, Ivan. Appreciate it. Great to have this awesome group together, talk about this super important topic. So yeah, as Ivan mentioned, I'm co-founder CEO of BreachRx. I come from legal side of the world, having practiced data breach litigation for a little over 20 years. So started in the early 2000s with some of the first data breach cases before the Federal Trade Commission, and have really kind of witnessed firsthand over and over again all these long-term, we call long tail consequences that come from any breach, and have a real passion for helping companies be better prepared for incidents so that they can deal with them appropriately, knock them out efficiently, and really minimize the business impact of them. And so and that's what BreachRx is focused on. We've built a platform that automates a lot of the workflow that a company across its business. So not just the security team, but security, legal, communications, the whole team that has to work through an incident. We've automated a lot of the workflows. We're tied into all of your regulatory responsibilities across. Now we've got 200 plus regulations in the cybersecurity space worldwide. And yeah, our focus again is just helping companies get back to business as usual as quickly as possible. And now with stuff like this, how can we help companies protect themselves and the people from the personal liability? And we'll talk a lot more about how you do that and how we're doing that with some of our customers today. But yeah, excited to dig in.
Awesome. Great. Thanks. Chris, how about you, man?
Oh, great to be here as well. My name is Chris Hendricks. I run Coalition Incident Response, CIR. We are the subsidiary of Coalition Cyber Insurance Company, and we do the on-the-ground digital forensics and incident response services for these folks. So we're doing the investigation, the remediation, and communication about these incidents on a day-to-day basis. And since its inception, CIR has handled thousands of incidents of various types. So while we're as perhaps not as well versed as Andy in some of the regulatory frameworks and so forth, what we certainly do is deal with these stakeholders on a day-to-day basis, right? As they're discovering these facts and trying to make assessments about what's material to their business, whether it's for day-to-day impact purposes or regulatory compliance purposes, we're certainly there on the front lines. I come from a background in cyber law enforcement, federal law enforcement, and military. So not the again the legal rigor component, but definitely familiar with the types of threats that we're talking about here and kind of the things that might motivate reporting under this rule. So hopefully between both of our backgrounds here, we'll be able to put something compelling together for the
Yeah,
audience.
I don't doubt it. And that's a good kind of maybe lead into this first question, thinking about the precedents, right? So, I mean, how far is the SEC pushing the precedents? I mean, they're really kind of demanding perfection here, but security professionals know all well that so much of the role is dynamic, so much of it is just managing risk and accepting risk. When you have the SEC kind of looming and really being this strict, do you feel like they're pushing a little too far, or is this actually maybe a good thing on the industry? I don't know who wants to take
Yeah.
that one.
Yeah, I'll kick things off. So yeah, I think that the intention they have is a good one. They want to encourage companies to have better cybersecurity controls in place, handle incidents in a responsible manner, to do so efficiently. Whether this is the appropriate way to do it and whether the SEC is the appropriate regulator to be doing it, I think is, kind of remains to be seen. And I think we're going to see some of the consequences and how that, how this is really impact them from a policy perspective. I think there's an acknowledgement that there's a lot more incidents that happen for companies than actually get reported. And so they've like honed in on that as like, okay, we got to make sure people are reporting. So we're going to up all these consequences. The unintended consequence for them is the deluge in volume that they're going to see, especially when you ask somebody to report in 4 days when the amount of information in the first 4 days after something's happened is pretty limited. So the floodgates are going to open. And I think it's going to be a very interesting year, and we'll see how well staffed is the SEC to deal with all of the notices that are going to come in.
I think I'll add a piece to this, which is that one thing that's encouraging to us is every day we see information security professionals having to tie like what they do to business impact, right? Trying to make the case for all the controls that they put in place and all the efforts that they take in advance of an incident, all the preparation and risk management. And sometimes that it's a challenging case to make about, okay, I'm doing all this work in order to prevent, right, some business impact. And I think this really forces teams to kind of think in that way, right? I mean, it's to draw these away from or in addition to technical decision makers, IT decision makers, infosec decision makers, and say, look, we have to have a collaboration at the business level, legal, compliance, operations, executives, and bring all of those voices in a way that, I think that's part of the journey of infosec in the last 20 years has been moving away from just this is a technical problem to this is a business reality. And so in that sense, I mean, I think there's something appealing about having a respected and in some senses feared business regulator kind of in this discussion, even if the actual regulation's imperfect. I think it's powerful to tie this to business consequences because they're real. And so, having, and maybe this will motivate some stakeholders that wouldn't otherwise have been motivated to play, to participate.
Yeah,
Yeah,
that
you make a really great point there, Chris. I think there's a common misconception that incident response is a pure security problem. And if you actually look at the costs that a business expends when it comes to dealing with a security incident, only 20-25% are really the security costs. 75% are the rest of the business. And that's why we talk to a lot of our customers. This is a business problem, and it impacts so many more aspects of the business. And you nailed it. You know, it's all the business units, communications, the leadership, and all those teams need to be well orchestrated, because the regulators are saying, hey, we're expecting surgical precision from the whole team. And that's, you know, a really high bar.
Yeah. To your earlier point, I think it's kind of funny. I mean, I would say the most likely outcome is often the most hilarious outcome. It would be kind of funny if all of a sudden the SEC started getting overwhelmed and bogged down with security incidents, and they were like, "Wait a second, this is harder than it." Maybe we should pull back a little bit, figure out which ones we want to go after and
Yeah,
prioritize.
I think a
And
lot of
people
people
just
have
be like,
been
"That's what we've been doing for the whole time, by the way."
well, that the recent thing they had with their Twitter account when
Oh my
the
God. Yeah.
blockchain issue, I think that made a few people chuckle.
Yeah, that was too easy. Yeah. Great, good. Yeah, so I like the point of connecting the dots between business outcomes, and when you think about business outcomes in the context of materiality for investor confidence, that becomes obviously a very important consideration. So speaking of kind of materiality, this is a very common question. We got this a lot. Who is really the right person or team to first decide materiality? Is that something that's the security team who's hands-on, or kind of the legal team looking at all protections, or risk management? I mean, it's some combination of all. Like, how do you guys kind of see that decision point of materiality? Because that's really what triggers we have to go file now.
Yeah, I think that you see, you know, it is such a multidimensional like decision to make, and I think a lot of companies are struggling with like, okay, who should we say makes the final call and saying is this material or not? It seems to me like across our customer base and a lot of the CISOs we talk to, GCs we talk to, having sort of a critical committee that is like, because there's, you know, the SEC lays out a number of different factors they want you to consider for materiality, and it's subjective across all these different areas. And so, you know, having security teams talk about what is the security risk here, having the legal team talk about what's the legal risk here, having the finance team talk about what is this going to do to the business and the operations, like what does this mean if we, you know, take this offline, et cetera. You need to have all of those inputs, and the security person alone isn't going to know all of those things. And that's part of this like issue is like, why should they be the one that's getting put up at the top with personal liability when all of these parts of the business really have to weigh in on it? So I think anyway, I'm kind of seeing as like a more common best practice is you're getting, you know, a committee that has, you know, 4 or 5 people, but they've got to be wired into this process, because it's like, you know, incidents are going to happen and you're going to have to make calls on things quickly. And so having, you know, 3 or 4 to 5 people sometimes even that are part of this committee to at least weigh in on each of these factors. And then, you know, maybe you do have the GC or a, you know, a CFO or somebody make the ultimate call. Like, okay, we're saying this is material.
One thing I'll maybe call out as well is that this isn't new to InfoSec. So cybersecurity folks having to collaborate with business stakeholders to decide if something's indeed, for example, an incident versus an event or something like this, like these sort of arbitrary distinctions between like when does it get real. This has been a part of security operations practice for quite some time. And I think what this, again, does is sort of promotes that to the business level, right? It says, and I think if the companies that do this most successfully are going to be those who don't throw the baby out the bathwater. They're going to say, look, we already have processes for assessing the impact of an incident and assessing when do I bring in extra vendor support, or when do I call insurance, or when do I, right? There's already kind of these decisions that get made and have been made for several years. And I think what we need to kind of think about this is in the context of existing processes, and bring in those stakeholders that Andy mentions and say, okay, well, look, maybe you weren't involved before, but we're not inventing something from whole cloth here. We have an approach now that needs to be a little more mature. Maybe it needs to be a little more ongoing, right? Because materiality can change. And I think there are some incentives and then I guess that's the last thing I'll say is, with a rule like this that triggers on materiality, counsel and discussions of what your definition of materiality is internally, and having that sort of well documented in advance is huge. We do a lot of work with counsel saying, okay, well, here's when clocks start, and here's when we really need to, make that judgment call. Again, not new to the infosec industry. I think what is new here is bringing it to this audience of people who didn't realize that these clocks start ticking at various times, and drawing them into a process that hopefully exists and predates this.
Yeah, yeah. Great point, right? This a lot of this isn't new. It's heightened in many ways, and I think bringing additional folks that have never really been this close to it is a positive thing in many ways. I think the clock ticking aspect of it is what makes it a little scary. So, talking about disclosure, I mean, so much of this is about disclosure. A lot of the questions that came in were around how how are they going to handle the 4-day disclosure requirement while simultaneously conducting the more formal investigation that could take weeks or months to really understand the impact. I mean, how are teams going to balance that with what they disclose right away based on the regulations, and then actually performing the full analysis?
Yeah, well, I can tell you like an approach that I think, one of the things just to know is like, okay, so you think about the SEC, they're going to be giving this Monday morning quarterback review of, okay, when did you know about something? And did you say, and did you notify us within 4 days? And knowing whether something's material or not on day one is a leap, to say the least a lot of times. And so the key that we've gone through with our customers is documenting what when, and really having a good audit trail for that. So on day one, when you may like believe, hey, we don't know enough to know this is material, it's important that you have shown like, hey, on that day we did this, we looked at the materiality and said no. And then, we got a little more, we knew a little more 5 days later, 2 weeks later. And then it was like, okay, I think we've crossed over the threshold here. This is material. Let's get our disclosure in order. We got 4 days to do that. But if you don't document that and have a really good audit trail for it, which a lot of people don't, they've like thought, oh, I'll just have a Google Doc and put this down, or I've got a ticketing system. The SEC is going to come in and say, wait a second, you guys knew something, or an analyst saw something on on day 30 days ago, and then you notified. If you don't have that paper trail to say like, no, we take materiality seriously, we started looking at it at the beginning, it wasn't enough at that stage. Just relying on a statement of somebody saying that without the paper trail, it is really problematic. And I think you think about the whole whistleblower aspect. I don't know if this is a question we're going to talk about later, but essentially, that by being an SEC rule, you throw in this whistleblower aspect where anybody in your company can be a whistleblower to witness, at what they call, a security issue. So if somebody knows that you knew about an incident on day one and you didn't notify till day 50, they have this financial incentive that if they go to the SEC and say, hey, business didn't do this right, if they and they're rewarded basically if that ends up in the company getting some kind of settlement with the SEC, they can get 10 to 30% of that award for providing that information. And so it's really tricky dynamic. And so I think that's again why documentation, having a really solid audit trail, and I don't want to make this all about breach risks, but that's like part of our like automated thing in the background is like just making sure it's all being recorded. So you say, okay, you want to know what we knew when? Here you go. Here's the report. And last thing I'll say with this is like I think a lot of the forward-leaning CISOs that I've been talking to in GCs is like, because this is now a SEC requirement, they basically said incident response records will be audited like financials. And so you got to think in that mentality, like your financial records, those need to be kept up and very easily transparent. You just need to think about incident response in the same way.
And I'll say because of those incentives that Andy just mentioned, I would expect prediction-wise that people will err on the side of there's no downside in some ways. I shouldn't say that. There's no compliance downside to over-reporting. So if you decide later there's not material, like you may end up deciding that it's better to just report on day one. Every incident that comes across my SIM, right, my security logging system, any ticket that I open, any incident that I declare, just send a preemptive materiality notification, right, and have some kind of canned initial report that just makes sure that like you can always say, yeah, we told you. That goes back to your point, Ivan, earlier about maybe the volume could end up
Yeah.
becoming an issue.
It's a
That we
startup
could,
idea. SOAR for SEC. Somebody
that's
go.
right. Well, when you have incentives or disincentives to, you don't want to play with fire on that 4-day clock, right? You don't want to be on the 5th or 6th day. Well,
Yeah.
then, to my eye, it just incentivizes everyone to, whether it's through automation or otherwise, find a way to make sure I have at least like a kind of boilerplate, initial notification saying, hey, kind of looking into it, could be material. I want you to know, and you'll have that volume that starts to seep in. And then you're wondering, well, are they really material and so forth? So I think
Yeah, and
the
you can tell by the filings, that have come through already. Only been a handful of them, but they're obviously very sparse on details because they're just like, hey, listen, we saw something, could be material. We're gonna file it. We still have a lot of work to do, but just so you know. But that's an interesting thing for the public to receive because and then the public gets hungry for more information and more details. And be like, oh, well, what's really the cause of this? And it's like if you have to do that disclosure so quickly, the public's going to be hammering on you for more information. You still got to come back and do it quickly, but at least covering that window of hey, you're not going to come back and say we didn't tell you about this. Like that's like minimum we got to do that, and having the documentation to be able to kind of prove
Yeah.
that is
Well,
key.
another thing that people should know too is like some laws, like a good example of this, if you're in financial services, New York TFS, they have this like catch-all trigger. It's like if you're notifying for another regulator, you owe them notice too. And so by having this SEC requirement, you might also trigger other notifications you have to do beyond the SEC one. And it's just something people need to be aware of.
That's a good point. Good. Well, we had a question coming in, and this reminds me we should probably say the disclaimer that none of this should be taken as formal legal advice. The question that came in from an attendee here is how are you structuring communication for these decisions with regards to attorney-client privilege? So, Andy, that's probably a good question for you.
Yeah. So that's super important in this process. And unfortunately, the way we've had a bunch of court cases on these issues specifically, I'm involved with this group called the Sedona Conference, and we put out papers on this topic. Basically, if you're doing this work in Slack, Teams, email, these different kind of business or like basically products you're using for other business purposes, a lot of that stuff is not good. Even if you have an attorney copied or seen it, that's not enough to protect it. And I think that's maybe a kind of misconception. It really important is that you're bifurcating this activity. So you need to be building a factual record apart from the place that you're having these privileged communications. Again, another plug for us. We actually facilitate that in our product, but that's the key. Whatever mechanism you want to have, you just need to make sure that those are separated and it's not part of an existing business system that you're doing. And ideally, it's a place that's out of band in case your systems are compromised. In case sometimes when email gets compromised, as I know, big reason why you guys exist is to help people with on the email front. That's a big issue.
Yeah. All right. Good stuff. Mark that as answered. Yeah. Got another one here. Great. Okay. Coming in on the chat. Let's see. While identifying if an event is material, would you advise companies notify a coalition and bring in or external counsel, especially looking at long-term impact for short-term cost and claims history?
Yeah, that's a great question. I can get to this one here, right? So maybe not everyone is aware of that approach, but when you make a claim to most cyber carriers, certainly to coalition, a big part of that initial kind of triage is one, is there kind of any need, and they tend to default to yes, for breach counsel to be present, an attorney to be present. So that is the standard practice in the US and the UK and in Canada, is to have counsel involved right from the get. And so in notifying coalition or your other cyber carriers, you're going to end up getting nudged, incentivized, pushed to having breach counsel involved. It's a big win in many ways. And I think they're going to be the ones who can give formal legal advice about, has a materiality assessment been accomplished? Let's talk to your internal counsel and other decision makers and committees and so forth. And those kind of conversations are often actually bifurcated, to Andy's point, away from the strictly digital forensic component of that response as well. So there'll be conversations where me and my team are talking about, right, find the bad guy, evict them from the environment and so forth. And then there's questions happening with sort of business stakeholders of, are we meeting clocks and timelines? And almost every carrier that I'm aware of has learned the lesson, long ago to kind of get those folks involved early. You're not going to find many people trying to scrimp on whether whether you have counsel involved early.
Yeah. Yeah.
I add another thing to that, and I don't know coalitions specifically where you guys have on this, but I review a lot of cyber insurance policies as part of the way we onboard customers is making sure that's your insurance obligations to get covered are included in the incident response workflow, which often are not even discussed in a paper incident response plan many people have. But it's news to a lot of people that actually you need to notify if it's a type of event that you think will need insurance coverage. You often need to notify the insurer almost before anybody else. So like oftentimes it's like within 24 hours. It's not the case where you go deal with an incident, hire a bunch of people, do all this work, and then you just, hey, can you come cover this claim? Here's the bill. That's not how it works. It is you've got to get them involved early, and they need to be part of your process going forward usually. And most, not all, but most require a level of approval before you take certain actions in order to get the claim covered. I don't know if Chris, if you want to
Yeah,
speak.
well, and I think, yeah, I'll double down on that a little bit. It's like I think it's you can look at it as an obligation. That is certainly one way to look at it. The other is to say, well, look, there's an immense amount of resources that you can bring to
Oh
bear
yeah,
early.
for sure, value. I didn't mean
Would
it
go
that way.
away, right?
Yeah,
It's like,
yeah.
and a good example of this, like with email, like just being able to reduce the materiality. So you can imagine a world where through an early report, someone like our claims team is able to claw back funds and make something that was $1 million loss a negligible or immaterial loss. I mean, that ultimately could have a bearing on a decision like this. So, by bringing in these services, that this is the whole kind of philosophy of having a more active insurance provider is saying, look, we have an incentive, the insurance company has an incentive, and certainly the client has an incentive to reduce the impact as much as possible. And if you can get that, if you have like a preliminary assessment that it is material, for example, and then you realize like by doing X, Y, and Z, I can reduce the impact to maybe below some threshold, that could be all part of how you communicate this or how maybe choosing not to notify having done that. So yeah, definitely there's a kind of incentive to do it in multiple ways. And a lot of that is to get the right services involved so that you can actually, and we, just to be clear too, we deal with many thousands of customers that the majority of which are not publicly traded firms. So, but this advice hopefully crosses all that boundary.
Yeah, absolutely. Yeah, and then us over here, Material, we're happy partners of Coalition in that effort for, yeah, I think I love what you're doing around deploying the services that have an impact on claims like that and being able to bring that proof. Hey, look, good controls, good proof. All right, good stuff. I want to bring it back to a little bit on the disclosure. We've talked, when you have legal counsel telling you what to say, that's great, but on day to day, it's not always the case. And I would say a lot of forward thinking security leaders, encourage their teams to talk about security internally and externally. So how do you think now with this looming, how should security leaders talk to their team about how they communicate security practices, how they talk about incidents, both internally and externally? And should they be watching out for stuff or giving different guidance than they may have in the past?
I just have a quick one here, Andy, which is legal advice will often be, for example, avoid the word breach. They're terms of art, right? They're words that have specific meaning. And then if you have internal teams talking about, well, we had a breach, or they're talking to their customers, or we think we had a breach, these carry regulatory, legal, and other potentially liability weight. And so there's already been a little bit of training internally to sort of use words like security event, security incident, things that are reasonably neutral. Hey, we're a security investigation, using words that say like, we're going to determine the facts. And then if there's some type of, if it's actually a quote unquote breach, you'll have the appropriate steps for that. So I think it's a matter of extending this and letting InfoSec people like cybersecurity nerds like myself say, look, you maybe think that you're using these terms in a sort of this casual way that seems like, what's the difference, right? Incident, breach, compromise, right? It's all the same. Letting people know that they can have these particular meanings is really powerful. And I think we, frankly, as a cybersecurity industry, probably could do a better job with our security operations folks and IR folks to say, just don't be too sort of candid about, or not candid, but don't be so reckless, if you will, with the precision of your language.
Watch those Freudian slips.
Yeah, I think that's all great points, Chris. I think the B word often gets like, forbidden. Like a lot of in-house counsel, a lot of time comes to be like, make sure nobody uses this word. Unfortunately, the way this SEC rule is written and the way a lot of other rules are written now, it's also cyber incident means something now. And so I know a lot of our customers and a lot of people I talk to, there is, event is now more like event of interest is kind of like a way to talk about what you're seeing and not calling it an incident. I mean, it's kind of, this is one of those ways that I feel like the legal world, I can say as a lawyer, just like does us all a disservice when you get like so impactful on people just being able to communicate words when they're just trying to actually solve a problem here. So I guess back to like sort of advice, and I should have said from the very beginning, I haven't already said it once, I'm not your lawyer. This is just me talking about my view, my personal view, and from my experience working with a lot of different companies. That one, you need to have a place. So first of all, having a policy in place where there is, a lot of times you'll say, okay, it's legal's decision in policy documents to say when something reaches officially, this is an incident. Officially, this is a breach. That's one way to approach this, and or maybe the CISO has the authority to escalate something, or a security leadership does. So that's one aspect of it to do. I think when it comes to communication, you need to be very clear as to the channels that you're going to do this communication and where you're going to talk about these issues. And so I think going back to this privilege issue we talked about here, this is another key point, is if you have a place that is dedicated to how you guys handle incidents, and you have a place to have that discussion where it's overseen by counsel so that it's bifurcated from the factual activity you're generating, you can have this more open dialogue that's not part of the discoverable record. And you can have, the legal involved in that piece and say, hey, not, this is going on, and just have a little more free flowing discussion. I think another place that some people do, they'll like use Signal as a place to have some of those discussions, because you can put sort of a time limit on how long those messages exist. And again, another best practice here is you need to have it built into your policy that is something that you're only have a retention of a certain period of time, not in a nefarious way because you're trying to cover up things, but it's just like a regular practice, and that this is the pure channel. That channel, whether it's Signal or whatever, is, we view it like phone calls. It's just our place to get coordinated. The more you can have that documented as that, and then, getting back to this whole thing is like, you've got to have good records of what you knew when, and you got to be able to, point to that after the fact. So you just need to have it, real clear understanding across your team. This is where we communicate these things. This is where we build our record here. And if you do that, you really set yourself up for success with, avoiding a lot of the personal liability and other issues that come as these things get bigger.
Yeah, that's a good thought there. It kind of leads into, or wanted to take this next, kind of on that response, right? So we've talked a little bit about some of the procedures, people, process, technology that, deserve heightened attention here, or potentially further investment. So if you're a security leader, and you're fighting for dollars and resources constantly, how can you use these regulations and the potential kind of impacts to maybe influence the business a bit more in terms of your budget, in terms of your priorities? Are there particular things that you could be surfacing and heightening in these conversations?
Yeah, I would say for sure. I think when you look at the stakes for businesses, when you don't, meet these deadlines, when you don't follow these regulatory obligations, and we're talking a lot about the disclosure in this AMA for SEC, but there's also a whole cyber governance aspect of this too, and it's a part that you've got to report on. And it's important is like what you represent to the SEC as to what cybersecurity practices you've put in place. That's their hook if you don't follow them. So, if the business wants you to put out a forward facing saying, hey, we're a very secure environment, we're doing all the right things, you've got to be able to back that up with the practice that's doing that, because that's the first thing. That's, if you look at these SolarWinds filings, that's a big piece of what they've gone after. They said like, oh, you were on your website, you were saying this and these different communications, you said this about your security practice, but meanwhile, you knew that you had all these vulnerabilities, you had all these challenges. There's a lot of policy reasons why that's, I don't agree with what's going on there, but I think that it's just, I think back to your question about getting resources. It's like, hey, if we want to present to the outside world that we take security seriously, we have secure environment, if we're holding personal information, we're doing the right things with it, we have to be able to back that up with we've got people, processes, and technology in place to actually do those things, because that's what the regulator is going to look at. And it's not just a slap on the wrist coming, and it's not just a fine to the business. They're looking at the executive team. If you listen to some of the interviews that Joe Sullivan's been doing, he's like, the judge said to me in the sentencing, he's like, why is it just Joe that's here? Why isn't the rest? Why isn't the CEO sitting next to him? Why isn't the rest of the C-suite? Think about all the people, the CFO, all the people that have to sign off on these SEC filings. They're going to be looking at everybody, and so I think I think understanding that the stakes are beyond the security leader, and they're not the only person, even though like they're often a focus right now. It's the whole executive team is going to be under the microscope.
Yeah, I
That's a
think.
good point. Sorry, I'll let you go ahead, Chris. Yeah.
Sorry, it just reminds me though that there's this executive team component, and then in addition to what Andy says, thinking about as a practitioner of IT, InfoSec, and so forth, thinking about the types of questions you're going to get under this type of regime in a way that you may not have before. So a good example might be system X goes down. What is the business impact of that? Right? That now needs to be answered in a timely and defensible way, in a way that perhaps it didn't before, right? So, you can say that this particular database server is important to us in some vague way, right? It's critical data. Well, what is now we have to go beyond that as InfoSec professionals and IT teams, even at smaller companies, to be able to say, again, in a defensible, might be in front of Congress type of way, that this is what this does for us. This particular set of assets, this particular type of data, this particular account, and so forth, that we have to be able to tie that to business impact in a way that frankly it's always in the frameworks, right, to tie it to business, but
Right.
just imagine putting yourself in that position when the CISO or the CEO is calling you and saying, okay, you just told me they're in this file server. Why does that matter to me? Right? Why does that matter to us as a business? Now it's not just academic, right? That has to be, very,
Yeah, that's right.
and and it requires investments, right? Asset discovery, data management, backups, these things that are maybe a little bit less sexy on the InfoSec spectrum of new and exotic controls. They're the ones that just have to say, well, do we even know what this system does? And I'll tell you, there's plenty of incidents that we work where, you're saying, oh, let me get back to you on that, boss. And you have to go and find out what this even relevant to anything. And so investments, I think, have to be made there from a technical and process perspective. Otherwise, you're hopeless.
Yeah, that's a good point, right? And it's always been hard for security leaders to tell the kind of fire prevention story when, versus the kind of firefighting. It was like the dollars are going to go to firefighting. It's hard to convince executives in charge of budgets that fire prevention is a necessary thing. But now maybe you can make that case a little bit better, because it is now not just a checklist compliance where it's like, hey, look, if we do all these things, we get this compliance, stamp. It's like, okay, you can still do all those things. You don't need extra investment. Now it feels like a little sharper. And so you can kind of go and say, hey, listen, all these things we've been talking about business impact, material impact. I mean, now you're on the hook too. So that's that could be another silver lining here, right? Is a little bit more emphasis on the fire prevention. And that brings up a couple questions that have come in here. You mentioned CEO liability, and all of a sudden the Q&A lit up. So I think we're in a good spot here. So at what point do you think that CEOs will become legally accountable in enforcement for security of the company, maintaining privacy and confidentiality, or customer data? And then the second follow on that is could passing an incident off to professionals early potentially de-risk for the C-suite? So a little bit of a twofer on that one on C-level liability here.
Well, I'll say off the bat, I'd say the CEO is already in scope. I don't think it's like to be determined. I think the CEO is already under scope. Actually, if you look at the Drizzly CEO, I know Drizzly. I think Drizzly might have closed its doors recently, but the Drizzly CEO got held personally liable for their security failures, and that's like something you can easily point to if you need a storyline, and if you need help with that, just reach out to me. I can feed you some of that stuff if that's part of your pitch to get more resources. But certainly when you're talking about SEC filings, the CEOs in scope as to like how they're resourcing things and what they're swearing by, signing off on.
Mhm.
And I think
Yeah.
on the
Sorry, go ahead.
de-risking side there for for the passing off to professionals early, I mean, I do think to Andy's point earlier that the overall framework approach of what are your controls, well, some of those controls are in fact saying that we have a procedure, standing procedure to involve this type of expert under these conditions, and being able to kind of defensively and reliably do that, and then hopefully do that in a way that's make that easy. I think will certainly go a long way towards showing that like sort of is handled in a defensible way.
Yeah, but what you don't want to happen in that scenario is the C-suite to throw the team under the bus.
Sure. And I guess I sort of read that as like external professionals. That is to say,
Yeah,
it's bringing in
right.
advice.
Yeah, no, it's your
That's
process. Oh, look, we pass it off to you. You didn't.
again, I think that's the record. You keep a good,
Yeah, that's
transparent
right.
record. Like that's how you protect yourself from that thrown under the bus
Yeah.
mechanism.
Yeah, I was being a little flippant there, but that
Yeah,
was into
yeah.
my next question of, there's personal liability looming at the C-suite potentially now, even at the practitioner level. I mean, how should individuals really think about protecting themselves while kind of maintaining that responsibility to the business? And, where are some of the tension points potentially where you find yourself in a lose-lose situation, maybe?
Yeah, I mean, I think that back to kind of what I said before is like we're moving to a phase where incident response records are audited like financial records. And so keeping good records, having a good solid audit trail of what you knew when, the actions you took, is one of the best ways to defend yourself as to taking the right actions at the right time. I think we went from a mentality, especially from the legal fields perspective, where early days of around data breaches and data breach litigation, there was this idea of like write nothing down. Don't say anything. Let's just pick up the phone and talk. And there's an element of like there's things that you probably still want to rather talk about on the phone rather than put on paper or record. But we're at a phase now where they're saying, hey, we're gonna shine a spotlight on exactly what you did when, what you knew when. So if you're not recording that in a good way, just saying you don't have those records is not going to be a good answer. And so I would fall back on that. Just say, really think about how you're keeping records so that you can prove you did the right things at the right time, and acted in good faith on what you knew at what time, and think hard about what your company's putting out from a policy perspective and what they're representing to say is your security practice, and like does it align with what you're able to actually do, and having that maybe lead to some hard conversations about resources and what you can actually say you're doing publicly.
I think also I wouldn't be a good representative of the insurance world if I didn't mention that not all of this can sometimes all these defensive or preventative or proactive work can still fall apart, and you end up sort of feeling exposed to some type of personal or overall liability. And I think a big part of realizing that this is moving into a sort of executive accountability function is to realize that there are additional executive risks that are being posed. And I'm not sure how familiar people are with this on the attendee list here, but this is an insurable situation, like where the behaviors of and errors and omissions and so forth of directors and officers of companies is a long-standing issue, right? There's a lot of requirements for executives of public companies, and people don't always meet them, or they're investigated even if they did meet them. And so being insured so that you have resources to help defend and address that is a big sort of part of your overall risk management strategy. Is like, if it does go sideways, are you appropriately covered from an executive risk standpoint, in addition to sort of cybersecurity? So I think that's again, I keep coming back to this theme, but treating this as the same way that all these other regulatory business components are treated, in some ways is a really powerful function, because it draws in these resources like executive risk insurance that maybe you wouldn't have otherwise thought apply to these type of decision makers.
Yeah, and that's such a great point, Chris. I'm so glad you said that. And I think one other piece that I would add that I think people probably are more more well aware of now. But your in-house counsel team, and I'm saying this as a lawyer that's been in that role, their job is to protect the business and from liability. And same when the company hires outside counsel, they're being hired to protect the business. And so sometimes there's some conflicts, a little bit of a rub there between what's best for the business and the stance that they take on things. And so that's why it's important, I think, to think about documentation and how you conduct your work, and how that's put together. And
You're
fortunately, you do need to be familiar with some of these big cybersecurity laws, and it's a little unfair. Like cybersecurity, people have to be experts on so many things, but you do need to be paying attention to this stuff.
So if you're an officer of a company, do you go to your company and say, I want to be part of the Dino policy, or do you go get your own? Or, if you go to
Yes,
your counsel or both?
you should talk to your broker, but yes, it's a both and scenario, right? It is important actually, and in a separate conversation, Andy and I mentioned that is that you need to know, are you an officer of the company? Are you covered, right, as part of that? And that's a reasonable conversation to have in advance of all this, is like, does this cover me? Where is my remaining exposure, if any? And talking to sort of a well-informed broker about this, it's like, this is why those folks get paid, is that they want to get good advice on saying, yep, we're confident that you got the right product and it covers you both as an officer and potentially as an individual. So
Yeah, and I think one thing to throw in there that maybe is a missed detail about the SolarWinds situation is that although Tim Brown is the CISO now, when they disclosed their breach, he was not. He had a different title, and so just because your title isn't CISO doesn't mean you won't be magnifying glass on if you're the leader of the security team or you're in the leadership of the security team. And so you certainly want to be thinking about DNO. And I know a lot of security leaders that are saying if they're getting a new offer at a company, like that's part of the requirement for me to join you is that you're going to add me to the policy.
I'll take the bonus and the policy. Thank you. Good. All right. Yeah, that's really helpful. I think that's really important that we were able to highlight that. A couple questions came in, something else I definitely wanted to highlight, and I'm glad that it got brought up. And we talked about this when we were originally syncing up, is, so much of the focus, because this is SEC, is these rules apply to public companies. But what is the trickle-down effect potentially for private companies, and how should they be looking at their responsibility directly and indirectly with the SEC?
Oh yeah, huge issue. So I mean, if your company services publicly traded companies, you can bet all this is going to trickle down into a lot of people. You think about all these regulatory notifications to notify. There's all these contractual notifications to notify, and so if what you're doing for a publicly traded company could be material to their business, if it gets disrupted or you have a breach with their data, all of a sudden you're pulled into this. And like if you look at a lot of the commentary with the SEC stuff, like they certainly are thinking about the vendors and not just whether it's not a defense for the publicly traded company to say, well, the vendor had this incident with our data. It's still your data, and that's still going to require them to report. And so it's why you're going to have, if the public company has 4 days to report, you can bet the deadline for you to report to them and the amount of information they want to get from you is going to be even more. And we're seeing that as we see like the contracts that people have and those contractual obligations that, again, need to be baked into the workflow, and not to talk too much about breach experts. Again, another piece of what we do.
I think the other real brief portion of this is that this is a consensus. It's part of an evolutionary sort of consensus of InfoSec policy regulation and quote unquote best practice. And that comes from these assertions, right? So if this stays the way it is and kind of proves out to become normalized, it will then bleed not just into behaviors, as Andy just mentioned, kind of from a direct liability standpoint, but just in terms of how you're educated as an InfoSec professional, it'll start to kind of pervade that sense of, okay, well, I should expect to be ready to do, to comply in this way, same way that HIPAA did and GDPR more recently, of like, it just changed everything. Even if you're not in Europe, people know what GDPR is and how it started to affect thinking. And then sure enough, it makes its way to sort of certain California regulations and others. There is a kind of a trickle down effect. We've seen it in past regulations. So, whether it happens immediately or more informally, it's going to trickle down if it's effective. And then frankly, as these discussions, that's why it's important to discuss this out loud, because the moment it sort of becomes normalized, it will find its way into sort of quote unquote best practice, which everyone asks that question, right? Public or private companies are saying, what's best practice? What do we think we should do? And then lawyers start to advise in that way and everything else, right? This just cascades from there.
Right. Yeah, super important to think about it for your private company. I mean, I'm a former employee of Okta, and a week after they had a major breach incident, one of their small healthcare providers had an incident too. But then Okta had to disclose that because they were a service provider. And so if you're that little small healthcare company, you just get thrown into the news cycle of an Okta breach just like that. That's a pretty significant thing if you're a private company. So just knowing who you're servicing, yeah, of course. And I'm sure I think Andy, you mentioned this, the pressure now on public companies for their service providers is going to be heightened for sure, because make sure that they have all the things properly documented, and just in case something happens that they also have to disclose. So it
Yeah.
is kind of this full cycle here. Yeah.
Well, and I think the other piece, hopefully everybody here knows, there's over 200 plus cybersecurity regulations worldwide, and so most are applied to everyone, whether you're publicly traded or not. So these aren't the only disclosure requirements; they're just the ones in the spotlight because they're very intense and they're for public companies.
It makes sense. Good stuff. Cool. One question that came in, kind of touched on this, but this is a good one. Could over-reporting as a strategy negatively affect your insurance relation claims history?
I could
Even
speak to that
non-insurance, but yeah.
directly. Yeah. So if you're applying for insurance in general, you're going to be disclosing your incident history. Now, I mean, I guess if your plan was to not disclose when asked, then I suppose this could, run afoul of that. But almost every application that we and our coalition will take applications from many of the other carriers, and it's not unusual to have to tell people like, did I have a material cybersecurity incident? And they wouldn't use necessarily that word, but they would, you are disclosing that stuff as part of your coverage history anyway. I guess this would just, and I think that's part of the intent of the rule, is to say, yeah, it stops you from pretending, lying, misleading, in a way. So I don't think it changes it per se. It's just, it gives that one extra layer of accountability to kind of like research in the past.
Well,
All right.
and
Well,
if you're not reporting, if you're not fully disclosing and answering your application truthfully to an insurer, that's a reason not to play a claim.
right. That's more, yeah,
You've
that's more damage.
misrepresented what you're doing.
Good. Well, we are close to time. I want to end on one question. It's not a spicier one. It's just it's more of a future thinking one. And I think we've touched on a few things where, in the sense that, hey, this isn't necessarily new from how we deal with regulations, and there's obviously 200 plus regulations that people have to deal with. But do you see how these particular regulations and the enforcement efforts by the SEC, do you see those impacting other compliance regulations, either big ones or regional ones? Are those looking and taking note?
I mean, outside of cybersecurity, like just get more broadly, is that what you mean?
Well, sure, yeah, it could be security regulations, or yeah, but even potentially outside. Yeah, that's a good thought. Yeah.
Oh, well, I mean, for sure, for security, yeah, I think this is like another tipping point. It's kind of the way GDPR in 2018 was the first time we saw 72 hours to report, and penalty could be 4% of your revenue. And that's why we've cascaded to 200 plus regulations, and all these international laws are percentages of revenue. And so now you're like, okay, the SEC is going to comes in now. They've got this 4-day requirement. You're going to say, okay, all these other regulators will, we want to be as intense as the SEC because we want the notice too. And so, yeah, I mean, there's no doubt in my mind you're going to see similar type of responsibilities coming from other regulators.
I think it's also important to note that this isn't, this is a bellwether in the sense of, it's this prominent, but it's not, this call for more transparency about what's going on is not new itself. This is sort of, in some sense, it's a result of ongoing discussions, right? It's one way that it's been codified, but I think this trend isn't going away, that people want to know more. Certainly for investors do, but other stakeholders as well. They want to know more about what are the facts out there, and finding ways to, to learn without telling people what to do necessarily, prescriptions on correction. They think like, look, getting more sunlight in here is going to be a good disinfectant, and that's not gonna go away. So even if this were to change subtly and the rule were to evolve, the trend of disclosure and quick disclosure, that's, I don't think, going anywhere.
Right. Awesome. Well, as I predicted, this was a fantastic session. Thank you both so much for lending your expertise to the conversation. Before we wrap, where can the audience find you if they want to learn more about BreachRx or Coalition?
Yeah, just head up to our website, breachrex.com. Hit me up on LinkedIn. Happy to connect and talk. Even if you just want some advice on how you might think about setting up your program, happy to help.
And similarly, Coalition Inc., coalitioninc.com. Yeah, and likewise, happy to discuss on the incident response side on LinkedIn as well.
Awesome. And then for us over here at Material Security, we're focused on securing your productivity suite, whether that's Microsoft 365 or Google Workspace, and just seeing how much of this is email centric, both as an entry point, but also the target for a lot of these breaches. So we offer a suite of email security, data loss prevention, and posture management tooling to help reduce risk and stop attacks. So you can find us at material.security to learn more. And with that, I think we can wrap. We used up just about all of the hour, which means it was a great session. So thank you again, both, and thank you everybody for attending. Be on the lookout for an email with the recording. I'm gonna write up some takeaways and post a blog post. Probably I'll try to do that by tomorrow, maybe by Monday. So be on the lookout for the video recording in that blog post shortly. And with that, I think we can wrap. Thank you, everybody. This was awesome.
Great. Thanks.
All right.